My name is Bele Arribas. I'm a lawyer specialized in digital law, TMT, and commercial law. I've been practicing in this field for 20 years now, and I'm the president of IFCLA, which is the International Federation of Computer Law Associations. It is important to build robust digital law systems. I very usually point out which is a myth, and that is that the internet or blockchain or the metaverse do not have a governing law. This is totally false. There are governing laws, be that the law of California, the law of Panama, the law of Hong Kong, etc. Further to that, there are also jurisdictions set for dispute resolution. The matter is if these provisions are fit to this new context where every interaction is transnational, globalized, and it's omnimodal. The best example on how important data are is GDPR, the first ever legislation, a piece of legislation that is intended to apply to players worldwide that offer their services to citizens located in the EU. There are some experts that are claiming that GDPR won't be enough because of, for instance, the challenges that the metaverse will pose. From there, specific technology-related privacy regulations should be enacted. For instance, IoT privacy regulations or directives, IORT, AI regulations, etc. Disruption is here for all of the industries and sectors. The legal sector is no exception to that. We are a traditional old-school sector in many ways. It is, I think, of the utmost importance that law firms try to adopt as soon as possible the tools that are already in the market. Tools used by law firms include AI tools, client firm communication tools, e-signature, document automation tools, research platforms tools, and the like. The adoption of them are more common in other contexts, in the US, for instance, but it is more and more common here in Europe as well. In the field of identity, there is a consensus that we have to shift the paradigm from the anonymity that we used to practice to a paradigm of identification in the use of the Web 3.0. The future use of identity wallets will enable the citizens to use their data in the way they want, with limited access for third parties, will make them able to identify themselves properly and, as I said, to give away the data that they need to give away in each context. In this context, blockchain and DLTs are instrumental. There is the hope that enacting the new digital rights charters that are now a work in progress in several jurisdictions worldwide will give the stakeholders a compliance obligation and the public an awareness and the possibility to exercise and to demand for these rights. Trustworthy and responsible technology is what we all as citizens should demand and what stakeholders should be envisioning as well to offer us for the future to come. So children should be granted special protection and safeguards. Newly enacted digital rights charters are key to that. Our kids, as they are digital natives, they use technology in a way that is very natural and non-critical. This poses risks that they are not aware of. Maybe someone that can be impersonating someone else on the internet is not something that they have in mind. The difficulty to give back to them what they gave away without any awareness that that would be used for training AI, for instance. to train algorithms, for instance, with all of the selfies and the platforms they are using today to, just to transform their images or photos for fun. Some claim that privacy will be something for the richer and not for the poor. So if you can pay for a service, you won't be giving away your data in exchange of the service, as opposed to those who use just services which are for free, but of course are trading with our data.